Ms. Underwood, are you ready to proceed with Mr. Herr?
Yes, Your Honor, thank you.
This is file 26-22642-FH, People of the State of Michigan versus Zachary Dwan Herr. We are here today for a pretrial conference in this case. Sorry, we're here for an arraignment in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. Bayonetto.
Good morning, Your Honor. Alex Bayonetto for the people.
Rhonda Underwood for Mr. Herr this morning, Your Honor. Thank you. At this time, Your Honor, we would waive the reading of the information, acknowledge its receipt and the receipt of the request for discovery and witness list, Your Honor. We would ask the court to set this for a very quick pretrial, enter a not guilty plea, and we anticipate this matter being resolved at the pretrial, Your Honor.
Sergio, could you grab the red folder from Francis, please? All right, I will enter a not guilty plea for Mr. Herr, and we can set this for a pretrial conference on June 3rd at 8:15 a.m.
Thank you, Your Honor.
So, Mr. Herr, your next date is June 3rd at 8:15 a.m. You will log in using all the same Zoom information that you used to log in this morning.
Yes, sir. Thank you, Your Honor.
All right, so you can go ahead and log out.
Thank you.
And the court will do the notices, correct, Your Honor?
Correct. Are you going to need to speak to Mr. Loftton?
I do not believe I do, Your Honor. Thank you.
Okay. Let me do this one first. File 25-22321-FH, People versus Marcos Anthony Buouie. We are here today for a final pretrial conference in this case, and we are proceeding today by video conference. The courtroom is also open to the public. First, can I have the attorneys place their appearances on the record, beginning with, looks like Mr. Sneed.
Sorry, I'm having some delay here. Isaac Sneed for the people.
Good morning, Your Honor. Brian Fry appearing for Marcos Buouie.
This is a final pretrial conference. It was scheduled for 8:15 a.m. It is 8:27 a.m. Mr. Buouie is not present here in the courtroom, and he is not logged into the Zoom session. I have everyone identified in the Zoom waiting room at this point. Mr. Buouie is not there. Mr. Fry, is there anything you want to say with respect to Mr. Buouie at this point?
Your Honor, we have trials scheduled in this case next week. I've made repeated attempts since our last court hearing to make contact with Mr. Buouie and have been unable to make contact. I don't know his whereabouts. I do know there's apparently a new warrant in district court for a new felony that's out right now and pending. I don't know if that is a factor or not, but I don't have any contact with him, so that's all I have to add. I would ask that the trial be vacated for next week.
Okay, Mr. Sneed, is there anything to add from the people's side?
Your Honor, just to inform the court, I have no objection to vacating the trial set for next week. The charge that Mr. Fry was referring to is a assault with intent to do great bodily harm, and that occurred in December of 2025. So that warrant's been pending since January. So his non-appearance or recall on that warrant has not occurred since then.
All right. I will vacate the trial dates. Obviously, there's no way to have a trial when we don't know where Mr. Buouie is. I am going to issue a bench warrant for his arrest for the failure to appear here this morning. I will set bond on that bench warrant in the amount of $50,000 cash for surety.
Thank you, Your Honor.
Thank you.
Thank you. Okay, this is file 26-22612-FH People versus Dimitri, Damon, Loftton. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Brenner?
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Good morning, Your Honor. Rhonda Underwood for Mr. Loftton this morning.
Okay, and Ms. Underwood, where do we stand with Mr. Lofton's case?
Mr. Loftton, as I understand it, is making payments. There have also been adjustments with some forgiveness that has been made. So I believe the Attorney General's office and myself, Your Honor, would request a 60 to 90-day adjournment to keep those things going, Your Honor. I believe this is Mr. Lofton's first pretrial.
All right, Ms. Brenner, anything from your perspective?
That's correct, Your Honor. I don't see the payments coming through yet, but it's my understanding they have been made through an income withholding order. So that's in process, but he has made great strides in reducing the arrears at this point.
All right, I will adjourn this then to August 5th at 8:15 a.m.
Thank you, Your Honor. I have no problem doing this stip to adjourn with Ms. Brenner's permission.
No objection. Thank you, Judge.
Okay, Mr. Loftton, your next date will be August 5th at 8:15 a.m. and you can log in using all the same Zoom info that you used this morning.
Yes, sir. Thank you.
Okay, so you're all set. You can log out.
All right. Thank you.
Ms. Underwood, do you need to speak to Mr. Novak?
No, I don't. Well, I kind of, not at this time, Your Honor. I made during this
All right.
proceeding.
Mr. Novak, you come forward and sit at the table here closer to television. This is file 24-51863-PP, Ashley Carpenter versus Montana Novak. We are here today for a hearing on an alleged violation of a personal protection order, and we are proceeding today by video conference and partially in person. Mr. Amadeo, are you involved in this case?
Yes, Your Honor. The prosecutor's office asked me to jump in on this one, so I'm kind of a special attorney on it.
All right. On behalf of Ms. Carpenter?
Yes, sir.
All right. You want to place your appearance on the record then?
Yes, Your Honor. William Amadeo, P7619, for on behalf of Ms. Carpenter. We appear via Zoom, consent to such.
And Ms. Underwood?
Could I have a brief break out with Mr. Amadeo, Your Honor.
Okay. All for the jail for Leah Cington.
Good morning, Mr. Buouie and Judge Zachary, Leah, Probation, please. And then Dwan hears.
Mr. Dagger Margosian, you need to speak to Mr. Merritt.
No, Your Honor, thank you.
Mr. Merritt, if you're there, I need you to turn on your video. All right, this is file 25-22173-FH People versus Brian Lee Merritt. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. Sneed?
Isaac Sneed for the people.
Your Honor, good morning. Michael Dagger Margosian for Mr. Merritt.
And Mr. Dagger Margosian, where do we stand with Mr. Merritt's case today?
Your Honor, today is the time and date set for a pretrial in this matter. I've reviewed the matter with Mr. Merritt. At this time, I'm asking the court to set the matter for a jury trial, please.
Okay, we had this set for trial once before for 2 days. Is that still what we're thinking?
Yes, Judge.
Yes.
Okay, Francis, can you give us a 2-day jury trial date, please?
Yes, Thursday, July 16th at 9 and Friday, July 17th at 9.
That's okay with me.
Yeah, that works for the
Mr.
people.
Okay, so let's do a final pretrial on July 8th at 8:15. And trial on July 16 and 17. The court will issue a scheduling order. Is there anything else we need to address today?
Your Honor, the only other thing I would ask the court to consider, there is a bond condition that Mr. Merritt have an alcohol tether for this case. My understanding, our office subbed in after previous counsel withdrew. So my understanding of that bond condition is that it's been on Mr. Merritt for, I think, over a year at this point, and there has been, on belief and information, there's been one disputed positive test. There was a hair follicle issue in the hearing. Regardless, in that amount of time and the financial obligation that it is costing Mr. Merritt, with those circumstances, I would ask the court to consider at this time removing the alcohol tether. He also has a GPS tether, but I'm not addressing that at this time.
Is there anything you'd like to say with respect to that request?
Your Honor, we'd ask that the scram unit remain on. There were some issues, I believe, set for hearing back in November. He was represented by Mr. Monterez at that time, who withdrew in February. So if you look at Mr. Merritt's history, we're looking at domestic violence incidents from 2010, 2012, 2021, 2022. In 2016, he pled to an RNO and an OWI second, which were reduced, attempt RNO, excuse me, reduced from an RNO and an OWI third offense. And then now we have this incident here where, he's guidelining to prison. So we believe it's appropriate to stay on until July. Thank you.
All right, I agree at this point, based on what I know, that it's appropriate to leave the scram unit in place. I appreciate that there's been a significant amount of time, but I don't believe that the time alone is a sufficient reason to remove that. I think there were valid reasons that it was put in place, and I think it should remain there until we have the trial. So I would deny. So, Mr. Merritt, you can log out for today. Your next date is July 8th at 8:15 a.m. You can attend that one by Zoom like you did today. All right, Ms. Underwood, are you ready to proceed on the Novak versus Carpenter case?
Yes, Your Honor, thank you.
We are back on the record in file 24-51863-PP Ashley Carpenter versus Montana Martin Novak. Ms. Underwood, where do we stand with the case at this point?
Your Honor, there are a couple things. First of all, it's my impression from reading the Register of Action that there was kind of a misunderstanding, and Mr. Novak was informed that the PO was not in place, and it turned out to be. So that is why there was some confusion. I have discussed the matter with Mr. Amadeo and my client, Your Honor, and basically what concerning is that Ms. Carpenter would like Mr. Novak to participate in AA and also to take some parenting classes, Your Honor. Mr. Novak has no objection to doing that. So we would hope we could resolve these issues today and perhaps dismiss the PPO and the violation at this point, Your Honor.
All right, Mr. Amadeo, is that agreeable with your client?
Yes, Your Honor. I did speak to Miss Carpenter. She says as long as he's in AA getting parenting classes, she'd be okay with dismissing the violation and the PPO. And actually, just so Judge Olsafer knows, that's an accurate statement, correct?
Yes.
Okay. So with that said, Your Honor, we're comfortable with the dismissals today. Just to note, and I did call Ms. Underwood yesterday, if there's any issues, we could always revisit it, but right now we just want to see him get help and them to try to co-parent together. So we will dismiss today.
All right. So we will dismiss the pending violation against Mr. Novak. That is the one dated April 13th. There has been some confusion. I did, as Ms. Underwood indicate, advise Mr. Novak on the record at one point that the PPO had been terminated. I just want to be clear, it has not been terminated at this point. There were a couple motions where they were filed. People didn't appear at some point. I don't know how I got confused, but I did about whether one had been granted. No motion to terminate the PPO has been granted, so everyone still needs to abide by that personal protection order until its termination date as originally set forth in that order.
Thank you, Your Honor.
And Ms. Underwood, if you want to prepare a stip in order to terminate, I'll speak to my client. She'd probably be amenable to that if you want to reach out to me.
Thank you.
Okay, thank you, Judge. Have a good day.
All right, thank you very much. So those here by Zoom can log out, and Mr. Novak, you're free to go.
Thank you, Your Honor. Have a good day.
Thank you, you too. All right, the person at the jail here, Ms. Covington.
Yes, hi. Good morning.
Sir Dagger Margosi, do you need to speak to Ms. Covington?
Yes, please, Your Honor.
All right, Ms. Underwood, you ready on Garing? This is file 26-22599-FH People of the State of Michigan versus James Raymond Garing Jr. We are here today for a pretrial in this case, as well as there are two pending contempts from when the case was in district court. First, can I have the attorneys place their appearances on the record, beginning with Mr. Bayanetto.
Alex Bayanetto for the people.
Rhonda, you wait for Mr. Garing this morning, Your Honor.
And Ms. Underwood, where do we stand with Mr. Garing's case?
Your Honor, this is our first pretrial in this matter. We are looking at some things and, seeing how things are proceeding. We would ask for another pretrial, Your Honor, probably 60 days out and see where we are at that point, Your Honor. And I'm happy to do this in order with Mr. Bayanetto's permission.
All right, Mr. Bayanetto, anything to address from the people's side? Set for June 10th at 8:15 a.m. July 10th, I'm sorry, July 10th.
Thank you, Your Honor.
Sorry. July 8th is the Wednesday.
July 8th.
July 8th at 8:15.
July 8th. Thank you.
Is there anything else we need to address with Mr. Garing's
Nothing, Your
case?
Honor. Thank you.
All right.
Thank you.
Mr. Noy, are you ready to proceed with Mr. Zoovers?
I certainly am, Judge. My system's loading up. Give me just 1 second. AJ, flip that to the laptop so the judge can see you. Yeah, the laptop's kind of janky, but it'll.
Okay, this is file 23-7221-CK, No Limits Homes LLC versus Zoover's Heating, Cooling, Mechanical. We are here today for a hearing on a contempt for failing to appear at a debtor's examination. First, can I have the attorneys place their appearances on the record, beginning with Mr. Troika?
Good morning, Your Honor. Dan Troika, appearing on behalf of the plaintiff, No Limit Homes.
Good morning, Your Honor. Charles Noe, appearing on behalf of AJ Zoovers and also Zoover's Heating and Cooling.
All right, so Mr. Zoovers was picked up on a bench warrant for failing to appear, so that's what's before the court today, but where do we stand? I presume, Mr. Troika, that you're more interested in getting the creditor's examination completed than anything else. Is that fair?
Your Honor, that is correct. I have had some conversations with Mr. Noe. I think that what we could agree on, if it works for Your Honor, is a review date. And in the meantime, I'd like to get a response to the document portion of the subpoena. And then at that point, we could go forward on the creditor's exam or whatever. That's my proposal. I think it would make sense for the court to have a control date, and I would be open to whatever Mr. Noe requests within reason.
That is correct, Your Honor. Mr. Troika and I have been in communication a few times since in the last week or so. If we could, Judge, set this matter. I know it was on a bench warrant on a failed to appear contempt. So what we'd like to do is set this matter for a review, preferably on a Monday morning, because it's a civil matter at its core, and just adjourn the contempt proceedings. And in the meantime, my client is going to provide obviously documentation through my office to Mr. Troika, so we can ensure compliance. I think the court hit the nail on the head that Mr. Troika and myself and Mr. Zoovers were all involved in discovery at this point to comply. And if we can just set this matter actually for a Monday afternoon or something like that, I think that makes more sense than a Wednesday for the court scheduling. But if the court prefers a Wednesday, that's okay too.
All right, so what the court may or may not do with respect to the contempt, I think, will depend upon how quickly we get this issue resolved on getting the information flowing. So what I'm going to do is adjourn this to June 3rd.
Thank you. That's Mr. Troika and I talked about 30 days. Sorry, Judge. But that's June 3rd.
June 3rd at 8:15 a.m. and we'll see where we stand at that point.
Will the court generate a notice, or should I prepare one?
Mr. Troika, if you would prepare that notice, I would greatly appreciate it.
All right, and that's Wednesday, June 3rd at 8:15?
Correct.
Okay, and I'll work with Mr. Noe with regard to the subpoena response.
All right. Thank you all for your time. Then you can go ahead and log out.
Thank you, Your Honor.
Thank you, Your Honor.
Ms. Underwood, do you need to speak to Mr. Quaylar?
Yes, please, Your Honor. Thank you.
Person.
Mr. Quaylar, I'm going to put you in a breakout session with Ms. Underwood if you'll give me just a moment.
Yeah.
No, it's not.
He's in the jail.
He's in order. He waived his arraignment. He waived his arraignment, so there won't be a hearing today. Francis, do we have a pretrial date for Matthew Moody?
Yes, just 1 second, Judge. June 10th at 8:15.
Thank you for everything, Your Honor. Yeah, he's just observing, Judge.
Sir Dagger Margosian, are you ready to proceed with Ms. Covington?
Your Honor, if I could just have a moment, I'm trying to see if we can resolve this case. I'm corresponding with Mr. Sneed right now.
Okay.
Thank you, Judge.
Okay, let's see. Gentlemen, Jail, I'm going to send a request to unmute that device. And you are Mr. Harris, correct?
Yes, sir.
Mr. Malero, do you need to speak to Mr. Harris?
No, Your Honor, I met with him yesterday at the jail.
Okay, 1 second. Mr. Hall, what case are you here for?
Your Honor, we're here on Miss Matson, who I did confirm with the Washtenaw County Jail has been writted. Oh, it looks like she is present, or I just saw her. Oh, there she is. Kaida Matson, Your Honor.
Okay, let me do that. Well, we've got the Wayne County Jail before we lose them. So this is file 25-22456-FH People versus Kaida Joe Matson. We are here today for a it's like arraignment on a bench warrant. And we proceed today by video conference. Miss, you are Kaida Matson.
Yes, Your Honor.
Ms. Madison, you have, you're being arraigned on a bench warrant for failing to appear at a bond violation hearing on February 4, 2026. That underlying violation alleged that you tested positive for THC and methamphetamine on January 2, 2026. And then you missed a test on January 9, 2026. You had in this case been convicted of one count of possession of methamphetamine, and the maximum possible penalty for that offense is up to 10 years in prison and or a $15,000 fine. Mr. Hall, do you want to place your appearance on the record?
Certainly, Your Honor. Joseph Hall appearing for and on behalf of Miss Matson, my P number 76832, Your Honor. Miss Matson appears via Zoom today without objection.
And how Ms. Matson wishes to proceed on this case.
Your Honor, we present today with not only a willingness and ability to admit responsibility for the bond violation, but also to proceed with an executed plea agreement, the documents for which were sent into the court early this morning. And I sent them in duplicate to Mr. Sneed. My staff did, at least, along with an advice of rights. So we appear with the belief that we are ready to resolve not only the underlying bond violation, but the case as well.
I'm sorry, I apologize. I misspoke. I was treating it as a probation violation. It's a bond violation. So Ms. Manson, you understand that the penalty for this would actually be for the contempt for the bond violation and for the failure to appear. The potential penalty is up to 93 days in jail and or $7,500 in fines.
Your Honor.
Okay. And I'm sorry, Mr. Hall, who did you send those documents to? Because they have not made their way to me yet.
Oh my goodness. I have my staff. Circuit Court Clerk at lenaway.mi.us. Mr. Sneed, did you get those documents?
Mr. Hall, I'm going to send you in the chat an email address to send those documents to.
Thank you.
Yes, I did receive them, Joe.
Okay. We'll make sure we get them to you, Your Honor, immediately.
Okay, so we'll pass this for a moment till I have those documents.
Thank you, Judge.
Okay, Mr. Malero, are you ready to proceed with Mr. Harris?
I am, Your Honor.
This is file 25-22314-FH, 25-22371-FH, and 25-22474-FH. People versus Dwan, Pfeiffer, Harris. We are here for pretrial conferences in all three of those files. There are also pending contempts for bond violations in the cases ending 3-4 and 371. First, can I have the attorneys place their appearances on the record, beginning with Mr. Harton.
Thanks, Your Honor. Good morning. Doug Harton, appearing today for the people.
Salvatore Malero on behalf of Dwan Harris.
And Mr. Malero, where do we stand with Mr. Harris's case today?
Your Honor, with respect to the files ending in 314FH and 371FH, it appears that the request for preliminary exam transcripts should be forthcoming within the next few days, I would expect. It looks like they were due on the 10th.
Yeah, I've got copies in the file, so they should be.
I don't see them.
I've got them too, Sam.
Okay.
Yeah, they were filed.
I have the one for the 374 or 474 file, but you have all three of them?
Yeah, yeah, they were filed.
Well, could we adjourn this then 2 weeks, Judge? I'll get those and then go talk to Mr. Harris, and then we'll get moving on this.
Judge, can I speak, please?
Sorry, Mr. Harris, I couldn't understand what you said.
I was asking to speak, or requesting to speak.
Well, you're represented by an attorney, so your attorney speaks to the court for you. Mr. Malero, what do you want to do?
Judge, I'm okay if he wants to speak. I cautioned him yesterday that not to say anything that could be used against him in any of these proceedings. He said he understood and he wants to address the court.
All right, what is it you'd like to say, Mr. Harris?
Your Honor, I would like to state for the record that I, Dwan Pfeiffer Harris, have been wrongfully arrested and incarcerated around about 250 days at the Lenawee County Jail. That is 2 months past my 180-day speedy trial ruling under my Sixth Amendment constitutional right. I have been told by my attorney, Mr. Salvatore Malero, since January that he will file a motion on my behalf concerning that issue and has not due to his own admittance that he has been too busy to do so because of his extra workload put upon him since the court's firing of John Glacier. If he had done so on the 181st day, I would have had a hearing before the prosecutor could file this 404B, which has no merit. Furthermore, transcripts for all three of my case files have come in, but no motion to quash has been filed. As you know, 317, 323, and 410 are the dates on which they were in. Well over a 90-day period that they should have been brought, that they should have come in. Me being here is hurting my case in family court with Judge Sala, in which foster care has filed abandonment on my 20-month-old son because I was arrested only 3 weeks after I was determined to be his legal father. My next court date is on the 18th, and I really need to be free. So to get my son out of the system because I'm all that he has. I don't have no family to take him, and that's it. I'm pleading. I'm placing myself further at the mercy of the court and asking to be released, not as a favor, but as a red-blooded American that has a constitutional right and wants to be a good father to his children. Thanks for your time.
Good job. Sir Malero, is there anything further you want to say about those issues?
Judge, I would just note that the court had no bearing in what happened to Mr. Glazer. I think that was a different entity. But that being said, yeah, I've made it known that I have an increased workload and my ability to get things out, but has been delayed. I've expressed that to Mr. Harris. I understand his frustration. I'm frustrated as well. However, since I will be able to locate these transcripts since the court and prosecutor have them, I don't know why they're not in my file. I did find the one in the other one. If the court could grant an adjournment for 2 weeks, I will obtain those and see if I can get this moving in the direction that Mr. Harris would like.
Mr. Hartung, anything you would like to say?
I would concur with everything Mr. Malero just said, Your Honor, but I would also add that this court did hold an extensive bond hearing a while back on this matter and did not change the bond, did not reduce the bond at the request of the defense, and did not increase the bond at the request of the prosecution. I think the court understood all the facts and laying out in the situation at that point in time, and there really hasn't been any change other than the waiting to get these transcripts.
All right, with respect to the bond request, I would agree with Mr. Hartung that the court did have a significant bond hearing in this case, and made appropriate findings that I would rely on again today for purposes of denying that request. With respect to the issue raised about the 180 days, I have the files, and it's clear that most, if not all, of the adjournments were agreed to or stipulated to, if not requested by the defendant in this case, and so that time does not count toward the 180-day limit that was referenced earlier. So I don't think there's an issue with respect to a speedy trial claim at this point in this case. If Mr. Harris would like to assert his speedy trial right at this point, I am happy to schedule this for trial right now.
Your Honor, without getting into too much detail, I offered that option to Mr. Harris yesterday, and unless that's changed, we would not be asserting that at this time. Is that correct, Mr. Harris?
Yeah, that's correct.
All right. Mr. Harris, you can let the, oh, I'm sorry, did we need a date in about 2 weeks? 2 weeks from today is May 27th. We can set it for May 27th at 8:15 a.m. Mr. Valero, would you do the stipulation and orders to adjourn?
Yes, I will, Your Honor. Thank you.
All right, Mr. Harris, you can let the officer with you know that you're done with court.
All right, have a good one.
Ms. Underwood, are you ready to proceed with Mr. Cuellar?
Yes, thank you, Your Honor.
One moment. This is file 26-22617-FH People versus Daniel Cuellar. We are here today for a pretrial conference in this case, and we're proceeding today by video conference. First, can I have the attorneys place their appearances on the record?
Alex Bayanetto for the people.
Rhonda Underwood for Mr. Cuellar, Your Honor.
And Ms. Underwood, where do we stand with Mr. Cuellar's case today?
There is a plea offer in place, Your Honor. We have to get Mr. Cuellar in to sign an advice of rights, and I would anticipate this case being wrapped up in short order at our next pretrial, Your Honor. And I would be happy. I'm sorry.
Mr. Bayanetto, is there anything we need to address from the people's side?
No, Your Honor.
All right, Ms. Underwood, we can adjourn it to next week if you think that's enough time.
I would like a little more time. Thank you, Your Honor.
We can do June 3rd.
That's fine. Thank you.
So June 3rd at 8:15 a.m. And will you do the stipulation in order?
I would be happy to do that with Mr. Bayanetto's permission.
Yes, please. Thank you.
Okay, on Kaida Matson, I have the advice of rights and the plea agreement, but it looks like we need an amended information. Unless one was filed previously.
Mr. Sneed?
Yes.
The judge was mentioning the need for an amended information.
Okay, we'll get that prepared. Sorry about that.
Your Honor, while I'm speaking, did we lose Miss Matson?
I just put her back in the waiting room because her device was causing some feedback, and
Yeah, it tends to be loud at the Washtenaw County Jail. I appreciate you, Judge.
call the jail and have them take Ms. Covington.
I'm right here.
Zachary, can you take Leah Cington and another right some pen to sign this?
They need something. They need something from you guys.
Yeah.
What is that?
The advice is right. So I hand this to you. Go ahead and read through it, and then there's a place for you to sign on the back, please.
All right, Mr. Casper, are you ready to proceed with Mr. Conlin?
I am, Your Honor.
Is file 26-22607-FH People versus Nicholas Michael Conlin. We are here today for a pretrial or an arraignment in this case. Pretrial conference, and we are proceeding today by video conference. First, we have the attorneys placed there on the record, beginning with Mr. Bayoneto.
Alex Bayoneto for the people.
Bert Castleberry, behalf of the defendant.
All right, and Mr. Casper, where do we stand with Mr. Conklin's case this morning?
Your Honor, this morning I sent over an advice of rights and a plea agreement that we are looking to accept this morning.
Okay, I do have those. Do you want to state the terms of the plea on the record?
Your Honor, there was an added count 2 of operating while intoxicated second offense. There is a sentence agreement, a combo agreement to a 9-month suspended jail sentence to be imposed if the defendant violates probation. There's no upfront jail. The addition, we would dismiss count 1, which is the felony, and the additional terms are that there's a pending district court driving while licensed suspended case that would be dismissed as part of this.
Okay, Mr. Bayoneto, is that a complete and accurate statement of the plea agreement?
It is, Your Honor.
Mr. Conlin, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
And you are Nicholas Michael Conlin?
I am.
Mr. Conlin, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to operating while intoxicated or impaired second offense?
Yes, sir.
Do you understand that the maximum possible penalty for that offense is a fine of $200 to $1,000 and 5 days to 1 year in jail, or 30 to 90 days community service, or both?
Yes, sir.
Are you satisfied with Mr. Castleberry and the advice that he's given?
I am.
Neither the prosecutor, defense attorney, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record here this morning. Is that correct, Mr. Banetto?
That's correct, Your Honor.
Mr. Castleberry?
That's correct.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you right now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Conlin, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No.
Do you understand that you're giving them up?
Yes, sir.
How do you wish to plead to the charge that on or about December 22nd, 2025 in the city of Adrian, County of Lenawee, State of Michigan, that you did commit the offense of operating while intoxicated or impaired, second offense?
Guilty.
Has anybody made any threats or promises to you to induce you to plead guilty to that charge?
No.
Do you understand that if I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes, sir.
Does the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Conlin to plead guilty today?
No, Your Honor.
No, Your Honor.
Mr. Conlin, other than as we've talked about on the record this morning, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
If your plea is accepted and you engage in misconduct, the court is not bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, sir.
Is it your own choice to plead guilty?
Yes, sir.
Okay, Mr. Castleberry, do you want to establish the factual basis?
I can do that, Your Honor. Mr. Conlin, on or about December 22nd, 2025, were you in the city of Adrian, County of Lenawee, State of Michigan?
Yes.
And were you operating a motor vehicle?
Yes.
And would you agree that your blood alcohol content was more than 0.08?
Yes.
And have you previously been convicted of operating while intoxicated?
Yes.
I have no further questions, Your Honor.
Mr. Banetto, are people satisfied with the factual basis?
Yes, Your Honor.
Has the court complied with MCR 6.302 B, C, and D?
It has, Your Honor.
It has, Your Honor.
All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Conlin has had full knowledge of his rights, and he has had competent counsel. The court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them other than as it's been addressed on the record here this morning. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for June 25th at 8:15 a.m. Mr. Conlin, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Will do.
Judge?
Yeah.
Will he be handled by district court since it's a misdemeanor?
Yes, sorry, that will be handled by district court. So Mr. Conklin, you will need to report to district court probation, Mike McCarron, this coming Tuesday at 8 a.m.
Okay.
All right, so you are all set for today then.
Thank you, Judge.
Thank you.
Thank you. Mr. Dagger Margosian, are you ready to proceed with Ms. Covington at this point?
I think we are, if the advice of rights has been signed and if the court has received a signed plea form.
Let's see. So, Ms. Covington, you received an advice of rights form. Have you signed that?
I signed it, but they didn't take it.
That's okay. We'll get it eventually. So we've got the advice of rights set. I don't have a plea form yet.
Okay. My staff should be sending it to the court.
I just handed the plea agreement to Mary.
Okay. All right, so this is back to file 23-21465-FH People versus Leah Covington. We are here today for an arraignment in this case. We're proceeding today by video conference. There's also 2 pending contempt of court for bond violations. First, can I have the attorneys place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Senator Michael Dagger Margosian for Ms. Covington.
And Ms., you are Leah Covington?
Yes, sir. Yes, Your Honor. Sorry.
Mr. Dagger Margosian, do you want to state the terms of the plea for the record?
Your Honor, Ms. Covington will be pleading guilty to count 2, possession of cocaine. The sentence would be under 7411 if eligible, and there would be no immediate upfront jail. The remaining charges in that complaint would be, in that information would be dismissed, and that is that's the total agreement.
Sure. Steve, is that a complete and accurate statement of the plea agreement?
Yes, it is, Your Honor. Thank you.
Ms. Covington, would you raise your hand, please?
Can I ask my attorney?
What do you want to ask?
No, never mind. Sure. No, go ahead.
Okay. Are you sure you don't have any questions that you want to ask him before you go forward?
I just was going to ask my attorney something, but that's okay. I'll ask him later. I know he's okay. That's okay. Come on.
Okay. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
And you are Leah Shaniqua Covington?
Leah Shaniqua, yes.
Ms. Covington, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2, possession of cocaine of less than 25 grams?
Yes.
Do you understand the maximum possible penalty for that offense is up to 4 years in prison and or a $25,000 fine?
Yes.
Are you satisfied with Mr. Dagger Margosian and the advice that he's given you?
Yes.
Neither the prosecutor, defense attorney, defendant, or anyone acting on the defendant's behalf has discussed possible sentence with the court. Is that correct, Mr. Sneed?
Yes, it is, Your Honor.
Mr. Dagger Margosian?
Correct, Your Honor.
Is that also your understanding, Ms. Covington?
Yes. Well, I didn't quite hear you. Can I hear you one more time what you said?
Nobody has discussed a possible sentence with me. Do you agree with that?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify if you wanted to testify. Do you understand, Ms. Covington, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of the rights I've explained to you?
No.
Do you understand that you're giving them up?
Yes.
How do you wish to plead to the charge that on or about December 22nd, 2022, in the city of Adrian, county of Lenawee, state of Michigan, that you did commit the offense of possession of cocaine less than 25 grams?
Guilty.
Has anybody made any threats or promises to you to get you to plead guilty to that charge?
No.
Do you understand that if I accept your plea, you're giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter that plea?
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Ms. Covington to plead guilty today?
No, Your Honor.
No, Your Honor.
Ms. Covington, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, just same thing you just said, no jail time up front. Same thing you just said.
Okay.
But you didn't promise it, but.
Other than as we've talked about it this morning on the record.
Right, no,
Oh.
no.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, sir. Yes, Your Honor.
Is it your own choice to plead guilty?
Yes. Trying to get this over with. It's been way too long. I'm just ready to get it behind me.
Mr. Dagger Margosian, do you want to establish the factual basis?
Ms. Covington, on December 22nd of 2022, were you in the city of Adrian, county of Lenawee, state of Michigan?
Yes.
On that date, were you in possession of cocaine?
Yes.
Did you have cocaine on you? Okay. Was that a yes?
Yes, I had a crack. Yes.
Okay.
Same
Okay.
thing.
Okay. And you did not have a legal right to have that controlled substance?
No.
All right. And you knew that it was a controlled substance?
Yes.
Okay. I'm satisfied, Judge.
Sir Sneed, are the people satisfied with the factual basis?
Yes, thank you.
Has the court complied with MCR 6.302 B, C, and D?
Yes, thank you, Your Honor.
Yes, Your Honor.
I will accept the plea. It's been given understandably, voluntarily, and accurately. Ms. Covington has had full knowledge of her rights and she's had competent counsel. The court has not made any agreement regarding the possibility of plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them other than as it's been set forth on the record this morning. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for June 25th at 8:15 a.m. Ms. Covington, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. If you do that interview, please be truthful about these offenses and about your background, about this offense and about your background.
Okay, are we gonna?
Yeah, Your Honor, it's okay. I got one last thing, if I can address the bond conditions, Judge.
Go ahead.
Your Honor, Ms. Covington does have, as the court indicated, she does have two contempts on this matter. They are for failure to appear. This case is relatively old. There are no victims in this matter. Due to her taking responsibility today, I would ask the court to consider releasing her on the contempts and reevaluate them on the day of sentencing. I think if there was a good faith showing by Ms. Covington from now until the date of sentencing, I think it would be appropriate to readdress those on the day of sentencing. So I would ask the court to consider releasing her today.
Mr. Sneed, do you care for any input on that request?
Your Honor, I would defer to the court's discretion. Thank you.
All right. All right. Well, the reason the case is old is because she failed to appear for 3 years. Not anything the court did. She has taken responsibility for the case today. I think with the understanding that if there's a failure to appear or any issues between now and sentencing, that the sentencing agreement would not have to be complied with by the judge, and there would be no opportunity to withdraw the plea. Sentencing could just move forward with disregard to the agreement. So based on that, I'm willing to give Ms. Covington an opportunity at a PR bond at this point. So I will do that. I guess the other issue I need to address is this is actually Judge Anselm's case. And so Ms. Covington has a right to, since I took the plea, she has a right to be sentenced by the judge that took the plea, which is me, or if she wanted to waive that right to be sentenced by Judge Anselm, she could do that. So, Mr. Dagerman.
Can I be sentenced by you, please? I would rather just keep it going with the same judge I'm with now.
Okay, so that is your right, so that's what we will do.
Thank you, thank you.
So June 25th at 8:50 a.m. Let's see. I'm going to put you in a breakout session with Mr. Stevenson from the probation department so he can collect your contact information.
Okay, okay.
Judge, can I go in that breakout room as well, please?
Yes.
Thank you.
Ms. Underwood, do you need to speak to Mr. Merritt?
I don't believe so, Your Honor.
Okay. This is file 25-22113-FC, 25-22132-FC, and 25-22133-FC. People versus Timothy Joe Merritt Jr. We are here today for a hearing on probation violations in this case, and we are proceeding by video conference today. Ms. Underwood, do you want to place your appearance on the record?
Rhonda Underwood for Mr. Merritt this morning, Your Honor, on these probation violations.
All right, and Mr. Hartung, are you appearing here? Or?
I will appear for this, Your Honor. Yes, Doug Hartung on behalf of the people today, Your Honor.
Okay. So Mr. Merritt was arraigned, I think, earlier this week or late last week on these probation violations, entered a not guilty plea. So Ms. Underwood, where do we stand with the situation today?
Mr. Merritt has a probable cause conference with Mr. Murphy tomorrow morning or the morning of the 14th, yes, tomorrow morning, on the cases that are in district court and the genesis of this violation, Your Honor. So of necessity, this matter will need to be adjourned on that basis. Since Mr. Merritt wishes and would continue his not guilty plea in this matter, obviously, Your Honor. So that's where we are at this point.
Okay. Mr. Hartung, is there anything that you would like to address?
No, Your Honor, we're really early on in the stages of the other case. Mr. Murphy and I spoke briefly about it, but he didn't have any discovery until yesterday. So we're backed up a little bit in terms of getting it moving forward.
All right, I will adjourn this then to June 10th at 8:15 a.m.
Thank you, Your Honor.
All right, Mr. Merritt, you can let the officer with you know that you are done with court for today. And Mr. Perney, are you ready to proceed with Mr. Cheryl's case?
Yes, Judge.
All right, this is file 26-22585-FH, People of State of Michigan versus Robert Daniel Cheryl Jr. We are here today for a pretrial conference and we're proceeding today by video conference. First, they have the attorneys place their appearance summary.
Hey, Alex Bayoneto for the people.
And good morning again, Judge. My name is Eric Perney here on behalf of Mr. Cheryl Jr., P79467.
And sir, you are Robert Daniel Cheryl Jr.?
Yes, Your Honor.
Okay, Mr. Perney, where do we stand with Mr. Cheryl's case?
Judge, the people have tendered an offer to reduce the charge to OWI second. They did supply me with a plea form. However, I received it yesterday and I was in court all day yesterday and I have not had an opportunity to execute that, to sign it back to the people and to your court. But my client wants to take advantage of that offer to have it reduced to an OWI second.
Okay, I can't take plea without having a signed advice of rights form, and my understanding is the prosecutor's policy is they need to have the signed plea form, so I can adjourn this. I can do it next week if that's enough time to get done what needs to be done.
That's fine, Judge. I apologize. I just didn't have a time to get it back, but all we have to do is sign it, give it to you guys, and we're good to go.
Okay, so we'll adjourn it to next week is May 20th at 8:15 a.m.
Okay.
And we'll get that taken care of at that point.
Perfect. Thank you, Your Honor.
Thank you, Judge.
Okay. So Mr. Cheryl, you can log out for today. Your next date's a week from today. You'll log in using all the same Zoom information that you used today.
Okay. Thank you, Your Honor.
Thank you. Arraignment also, so I can go yesterday. See his charges here. Okay, what were we looking for? Amended information on Kaida Matson? Mr. Sneed, did we get that amended information on Kaida Matson?
Yes, Your Honor, it has been prepared. Was sent at
I'm bringing it to you
9:25
now,
a.m.
Judge.
Okay, then we are back on the record in file 25-22456-FH, People versus Kaida Matson. I do have an advice of rights signed by Ms. Matson, that plea agreement and amended information. So at this point, we are ready to proceed. Mr. Hall, would you like to state the terms of the plea agreement on the record, please?
Certainly, Your Honor. In exchange for a guilty plea to the added count to attempted possession of methamphetamine, the people would agree to dismiss count 1 and any habitual offender supplements, as well as make a sentencing recommendation of no MDOC, no immediate jail, so long as defendant is engaged in or has completed inpatient rehabilitation. And the people also further agreed to not charge the controlled substance supplement.
All right, Mr. Sneed, is that a complete and accurate statement of the plea agreement?
Yes, it is. Thank you, Your Honor.
Ms. Matson, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
And you are Kaida Matson, correct?
Yes, I am.
You've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2, attempted possession of methamphetamine?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 5 years in prison and or a fine of $7,500?
Yes, I do, Your Honor.
Neither the prosecutor, defense attorney, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record here this morning. Is that correct, Mr.
Yes, it is, Your Honor.
Yes, Your Honor.
Is that also your understanding, Ms. Matson?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Ms. Matson, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes, Your Honor, I do.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes, Your Honor, I do.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of the rights that I've explained to you?
No, I do not, Your Honor. Thank you.
Do you understand that you're giving those rights up?
Yes, Your Honor, I do.
How do you wish to plead to the charge that on or about June 23rd, 2025 in Madison Township, Lenawee County, Michigan, that you did commit the offense of attempted possession of methamphetamine?
I plead guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, Your Honor.
Do you understand that if I accept your plea, you're giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Ms. Madison to plead guilty?
No, Your Honor.
None, Your Honor.
Ms. Madison, other than as we've talked about on the record today, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, Your Honor.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, I do, Your Honor.
Is it your own choice to plead guilty?
Yes, it is, Your Honor.
Mr. Hall, do you want to establish the factual basis?
Yes, certainly, Your Honor. Ms. Matson, is it true that on June the 23rd of 2025, you were present in Madison Township, that being Lenawee County?
Yes.
And at that time, did you knowingly possess a substance that you knew to be methamphetamine?
Yes.
And is it also true that you have no legal ability through any sort of special dispensation or privilege to possess methamphetamine?
That is correct.
Thank you.
Mr. Sneed, are the people satisfied with the factual basis?
Yes, thank you, Your Honor.
Has the court complied with MCR 6.302 B, C, and D, Mr. Sneed?
Yes, Your Honor.
Mr. Hall?
Yes, Your Honor.
I will accept the plea then. It's been given understandably, voluntarily, and accurately. Ms. Madison has had full knowledge of her rights and she has had competent counsel. Court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, anyone acting in the interest of any of them. I will refer this matter to the probation department and set sentencing for June 25th at 8:15 a.m. Ms. Matson, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Yes, Your Honor.
Your Honor, very briefly, two things. One, on the 25th, I'm going to be out of town. If there's another date that would work for the court, I would greatly appreciate that.
Are you available on the 26th, or are you out of town that day also?
I'm out of town. Yeah, I leave Wednesday night too. I'm just heading up to my cottage. Frankly, I don't know if I could log on. Well, it's probably easier that we could just look at another date.
So the next available date would be July 12th, July 2nd, I'm sorry.
I am available that day, Your Honor.
All right. So we'll do July 2nd at 8:15 a.m.
Thank you, Judge. Additionally, on this file, Your Honor, we are prepared to resolve the bond violations that were initially discussed by the court this morning. By way of further information, and I believe we've provided the same to Mr. Sneed, Ms. Madson did attend and complete, on information and belief, inpatient treatment of a stint of 28 days in the Oakdale Recovery Center. That was residential treatment. Their aftercare recommendation is that she begin outpatient treatment that on information and belief begins next week, early next week. If we were able to admit the nature of the violation, Ms. Madson has been in the Washtenaw County Jail for some period of time. She has obviously been sober while there, and we're looking to get her situated. And it will take Washtenaw County, who I've already discussed with the prosecutor and meeting with the prosecutor and judge later today. It'll take an amendment of their situation as well. However, the idea would be a potential release so that she could obtain outpatient treatment as recommended by Oakdale Recovery. Mr. Sneed, did you in fact get the certificate that was sent over?
Yes, I did.
Oh, okay, excellent. I just want to make sure that you were able to obtain that. But we are able to resolve and admit the bond violation at this time, Your Honor.
Okay, Ms. Matson, you understand you have a right to a trial on the bond violations as well?
Yes, I do, Your Honor.
And you understand that throughout that trial, you would have all the same rights that I just explained to you with respect to the underlying criminal charge?
Yes, sir, Your Honor.
How do you want to plead to the charge that you violated your bond conditions by testing positive for THC and methamphetamine on January 2nd, 2026, and then missing a test on January 9th?
I accept full accountability for my actions, Your Honor. I plead guilty.
Right, and how do you want to plead to the charge that you violated your bond conditions by failing to appear in court for the bond violation hearing on February 4, 2026?
I plead guilty. I accept full accountability for my actions, and I apologize.
You understand, again, by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've already explained.
Yes, Your Honor.
Has anything been promised to you in order to get you plead guilty to those bond violations?
No, Your Honor, nothing.
Has anyone threatened you in any way in order to get you plead guilty?
No, Your Honor.
Again, if I accept the plea, you're giving up any and all claims that the pleas were given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the pleas. Do you understand that?
Yes, Your Honor, I do.
Is it your own choice to plead guilty to those?
Yes, Your Honor.
You had bond violations in this case that prohibited any use of a controlled substance. Is that correct?
That is correct, Your Honor.
And you also had a bond condition that required you to test periodically. Is that also correct?
That is correct, Your Honor.
And did you test positive for THC and methamphetamine on January 2nd, 2026?
Yes, Your Honor.
And then did you miss the test on January 9, 2026?
That's correct, Your Honor.
As a result of that, the court sent out a summons for a bond violation hearing and set the hearing for February 4, 2026. And you did not appear at that hearing. Is that correct?
Correct, Your Honor.
All right, I will accept the pleas. They've been given understandably, voluntarily, and accurately. Ms. Matson's had full knowledge of her rights and she's had competent counsel. I will set sentencing for the same date as sentencing on the underlying. And so, Mr. Hall, what is it you are requesting with respect to her bond situation and the ability to attend treatment?
Thank you, Your Honor. The request is to amend her bond, incorporate the idea that she follow the aftercare recommendations of Oakdale Recovery Center, which would be to attend the already scheduled outpatient treatment with Catholic Social Services in I believe that's in Washtenaw County. That's already set up. And that she would be allowed to be released, Your Honor, to attend outpatient treatment. That is in line, just for Your Honor's information, my conversations with Patrick Nachtrieb, who is the specialty services coordinator at Washtenaw County Jail, who states that by virtue of Miss Matson's completion of Oakdale recovery, that it's unlikely that she'll be recommended or accepted into an additional residential facility. And that it looks like proceeding with their aftercare recommendations is what's in store as far as the eyes of specialists that have looked into it, Miss Matson's situation, at least in Washtenaw County. So my request would be to allow her conditions that would allow her release, but require her participation and signing of releases as it relates to Catholic Social Services outpatient treatment program.
All right, Mr. Sneed, anything you want to say about that request?
No position on that, Your Honor. Thank you.
All right, at this point then, I will modify Ms. Matson's bond to a PR bond with the condition that she, all of the previous conditions, but in addition to those conditions, that she participate in outpatient treatment with the Oakdale Recovery Center, that she sign any releases necessary for our pretrial services coordinator, Darren Post, to be able to communicate with them and ensure that she is attending that treatment and doing well in that treatment. And that she is not already a condition that she report to Mr. Post periodically as directed by Mr. Post. So Ms. Matson, you'll need to contact Mr. Post as soon as you are released from Wayne County.
Washington, and thank you very much, Your Honor. And just for further clarity of the record, the outpatient treatment is at the recommendation of the Oakdale Recovery Center, but that Oakdale Recovery Center was the residential treatment program. Catholic Social Services is the provider of services for the outpatient treatment, just to clarify the record.
Okay, thank you, Mr. Hall. That's outpatient with Catholic Social Services.
Thank you again, Your Honor. Sorry about the extended record here. Thank you, Mr. Sneed, for as well for facilitating today's hearing.
Thank you, you guys.
Okay, take care. I think we're all set then, Ms. Matson. You can let them know that you are done with the court.
Thank you, Judge.
Thank you, Judge.
For Mr. Miller. Michael Miller, it's not on our documents, Judge Ansel's.
Oh, okay.
Ms. Underwood, have you had any communication with Paul Cherry?
I left a message for Mr. Cherry. He usually always appears, Your Honor. I'm surprised we don't have him if we don't.
Okay. So this is file 22-20683-FH, People versus Paul Edward Cherry. We're here for a status conference on probation violation regarding payment of restitution and Mr. Cherry's filing of, I believe, a bankruptcy case. There's a notice of bankruptcy filing in the file. Ms. Underwood, do you want to place your appearance on the record?
Rhonda Underwood for Mr. Cherry this morning. As I told the court, Your Honor, I did reach out to Mr. Cherry yesterday and left a message. I have not heard back from him. It's highly unusual for him not to attend. I would point
sorry. I would agree with that. Mr. Cherry's had numerous hearings over the course of several years in this case, and always has attended. So I'm inclined to just set this for another hearing date, and I would think that he would attend next time. He's got an issue or what, but so I will adjourn this to June 10 at 8:15 a.m.
Thank you, Your Honor.
Thank you. Call for Michael Turner.
Good morning. Could we also get Michael Turner? Thank you.
Okay, Mr. Rocket, do you need to speak to Mr. Miller?
No, Your Honor, I do not.
All right, this is file 26-22637-FH and 26-2268-AX. We are here today for an arraignment in the file ending in 637 and for an extradition hearing in the file ending 625. First, let me have the attorneys place their appearance on record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Dylan Rocket for Mr. Miller.
And sir, you are Michael Allen Miller.
Yes, yes, sir.
All right, Mr. Rocket, does Mr. Miller wish to have the information read this morning?
No, Your Honor.
And do you know how Mr. Miller would like to proceed today?
If possible, Mr. Miller would like to, I believe there's a plea agreement in his file. Mr. Miller would like to plea to the plea agreement.
Okay. And so that plea agreement is to plead as charged to count one with a sentencing recommendation that there be no further jail or probation at the time of sentencing and dismissal of the habitual offender notice. Is that a complete and accurate statement of the plea agreement?
Yes,
Yes,
Your
it
Honor.
is.
All right. Mr. Miller, would you raise your right hand, please?
Am I able
Sorry,
to?
yeah, sorry, I didn't realize you had a cast there. So do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes,
And you are Michael Allen Miller, correct?
yes, yes, sir.
Mr. Miller, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count one, assaulting, resisting, or obstructing a police officer?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 2 years in prison and or a $2,000 fine?
Yes, yes, sir.
Are you satisfied with Mr. Rocket and the advice that he's given you?
Yes, sir.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Sneed?
Yes, it is, Your Honor.
Mr. Rocket?
Yes, that's correct, Your Honor.
Is that also your understanding, Mr. Miller?
Yes, sir.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand. You have the right to a speedy public trial by jury. You could have a non-jury trial. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Miller, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, sir.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes. Yes, sir.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of the rights that I've explained to you?
No, sir.
Do you understand that you're giving those rights up?
Yes. Yes, sir.
How do you wish to plead to the charge that on or about April 16, 2026 in the city of Morenci, County of Lenawee, State of Michigan, that you did commit the offense of assaulting, resisting, or obstructing a police officer?
Guilty, Your Honor.
Has anybody made any threats or promises to you to induce you to plead guilty to that charge?
No, sir.
Do you understand that if I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea?
Yes, sir.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Miller to plead guilty today?
No, Your Honor.
No, Your Honor.
Mr. Miller, has your attorney promised you any particular sentence or estimated what your sentence would be other than as we've discussed it on the record?
No, sir.
If your plea is accepted and you engage in misconduct, the court's not bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, sir.
Is it your own choice to plead guilty?
Yes.
Mr. Rockett, do you want to establish the factual basis?
Yes, Your Honor. Mr. Miller, were you at the Morenci Dollar General on or about April 16th, 2026?
Yes.
Did you have a contact with a Morenci Police Department officer, Logan Edmondson?
Yes.
And did he ask you for your identification?
Yes.
And did you provide your full name and date of birth to Officer Edmondson?
Yes.
Did Officer Edmondson advise you that you had a warrant out of Ohio?
Yes.
And after he stated that you would be placed under arrest for said warrant, did you run from him?
Yes.
And you knew that Officer Edmondson was a police officer?
Yes.
All right. Does that satisfy the court?
Mr. Steen, are people satisfied with the factual basis?
Yes, thank you.
Okay. Has the court complied with MCR 6.302 B, C, and D, Mr. Steen?
Yes, thank you, Your Honor.
Yes, Your
Mr.
Honor.
Rockett? All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Miller has had full knowledge of his rights, and he's had confidence. Court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation. And we can set sentencing. The This is Judge Anselm's case, Mr. Miller, so you have a right to, since I took your plea, you have a right to be sentenced by me. If you would prefer to be sentenced by Judge Anselm, who normally handles the case, you'd have to waive that right to go back to her court. If you know what you'd like to do.
Your Honor, I think if it was possible, maybe just whatever option would allow me to possibly get closer to being able to resolve the situation in Ohio. So and if that could happen as whatever the more prudent option or expeditious, but
Your Honor, I believe what Mr. Miller is trying to get at is he would like to be sentenced as soon as possible to resolve his case in Michigan and then attend to his cases in Ohio. So if we could request whichever judge has the soonest availability for sentencing.
Sierra, are you there?
I am, Judge, but I do not have Judge Anselm's books. Becky is working remotely today.
Judge, there should be a list of dates that she has that was with his file.
Oh. I do not believe I did. I'm sorry. So it looks like the earliest date available is June 25th, and that would be before me. So I'll set it for June 25th at 8:15 a.m. All right, and Mr. Miller, have they given you waiver of arraignment forms at the jail to sign?
It's been a while, but I think that where it was left was that they were like that the waiver was signed by me and that it was just put on hold for a time, but I think that I did sign something before, but
So you would, well, no, you would have, you have to sign them on the record. So you may have signed some things, but you haven't, you should not have signed what
okay.
Need to have you signed today. All right, so given that he needs to remain here until the sentencing, what I'm going to do is adjourn the hearing on the extradition until the same sentencing date of June 25, and then we have a sentence taken care of. We'll proceed with the extradition. Is there anything else we need to address today?
No, thank you.
No, Your Honor.
All right, Mr. Miller, you can let the officer with you know that you are done with court for today.
Yes, Your Honor.
Okay, can I ask you to call for Michael? Ms. Underwood, you need to speak to Mr. Turner.
I don't believe so, Your Honor.
This is file 25-22164-FH, People versus Michael Joshua Turner. We are here today for a probation violation pretrial. We're proceeding today by video conference. Ms. Underwood, would you like to place your appearance on the record?
Rhonda Underwood for Mr. Turner this morning, Your Honor.
And Sir Michael Joshua Turner?
Yes, Your Honor.
All right, Ms. Underwood, where do we stand with Mr. Turner's case?
Your Honor, Mr. Turner has a pretrial on the misdemeanor in this matter, which is the genesis of this matter, I believe on June 2nd, Your Honor, with Ms. Malaturno. So we would ask that this be put out till after then, Your Honor. In addition, Your Honor, we would ask, being it has to be put out that far, if perhaps the court would consider a small bond in the case with the provision that is only active if Mr. Turner makes bond on the district court case, Your Honor.
All right, I'll adjourn this to June 3rd at 8:15.
Thank you, Your Honor.
Given that the allegations in this case are, the underlying offense here was aggravated domestic violence and assault with intent to do great bodily harm. No, I'm sorry. So assault with a dangerous weapon is what he was convicted of. But the allegations here are that he committed an act of domestic violence and that there was contact with someone apparently there was supposed to be no contact with under the terms of his probation. I'm not comfortable reducing the bond in this case, so I deny that request.
Thank you, Your Honor.
Mr. Turner, you can let the officer with you know that you are done with court for today.
Okay, thank you, Your Honor.
And let's see, Mr. Amadeo, what case are you here for?
Your Honor, they told me Richard Lake has a bond violation.
Yeah, I will call for him right now. Can you call for Richard?
Okay, thank you, Judge.
Your Honor, is there a pickup?
There is, but we do not at this point know what court is appropriate to see him.
Thank you.
I think he is in sobriety court, but we were tracking that down to get that. So maybe we do have it figured out.
There's a warrant that you need to sign that Julian has for him.
Yeah.
Are we doing this one? Okay, I'll send it to the jail and I'll send it to Rhonda and then I'll bring it back.
Apparently, we are going to do that pickup. It's Mr. Lamb. So, yeah, we're going to circulate the paperwork right now, and we'll call for Mr. Lamb. All right, the gentleman on the Samsung device, can you tell me your name?
Oh, Cherry.
Oh, Ms. Underwood, do you need to speak to Mr. Cherry?
Yes, if I could just for a second, Your Honor. Thank you.
One moment.
Mary Judge Olsavers, could we finish up with Ella Lamley and Richard Lake, please? Thank you.
Judge, who did you want to join that breakout room?
Just Ms. Underwood and Mr. Cherry.
Okay, it came to me, that message.
Yeah, I don't know what happened. That it acted a little weird.
Okay.
Right, the gentleman at the jail, can you tell me your name?
Sure, Noah Lamley.
All right, 1 second, sir. Okay, so this should be heard by Judge Morgan. Mr. Lamley's case was reassigned to Judge Morgan because he is in ET court. There's an order of assignment dated October 10, 2025. So I apologize for the confusion. We're going to send this downstairs to Judge Morgan. And so, Mr. Amadeo, you'll need to get in touch with them for when they're going to be able to do that arraignment.
Okay, thank you, Your Honor. Have a good day.
Sorry about the confusion.
No problem at all. See you, Judge. Bye.
Mr. Lake, you can let them know that you are done with court for right now. You'll see Judge Morgan sometime later today.
Thank you.
All right, and the other gentleman at the jail, you are Mr. Lake. Where do you go? You can call him back and let him know they need to log Mr. Lake back in. He disappeared.
Judge, I think there was just some confusion there. For Noah Lamley, I think you called him Richard Lake, and Sergio just brought me back Noah's file.
Noah, the file that was he just brought back to you should be Noah Lamley, and that's assigned to Judge Morgan.
Okay, and then the Richard Lake was with Amadeo for the violation of bond conditions.
Oh,
yeah.
So, yeah,
could you call Mr. Amadeo?
okay, well, we need Richard.
Yes, I will.
Noah Lamley. Well, Noah Lamley needs to see Judge Morgan. Richard Lake needs to see Judge Wolhousen. We might have mixed people up. Only needs Morgan, yep, Richard Lake needs Judge Wolhousen. Jail's just as confused as everybody else.
Right, Mr. Goldstein, are you ready to proceed with Ms. Madison?
Yes, Your Honor. That's assuming I can get my camera to work.
Right, Mr. Lake, we'll proceed once your attorney gets logged back in. I'm sorry for the confusion.
Yes, sir, no problem. Can I say a couple words first? You want me to wait?
You have to wait till your attorney is here. This is file 25-22455-FH, People of the State of Michigan versus Felicia Madison. We are here today for a hearing on defendant's motion to modify bond, and we are proceeding today by video conference. First, they have the attorneys place their appearances on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
David I. Goldstein appearing on behalf of the defendant.
And Miss, you are Felicia Madison.
Yes, sir.
All right, Mr. Goldstein, this is defendant's motion. You can proceed with any arguments you have.
I'll make it very brief, Your Honor, because I always try to make my motions as detailed as I can. But I would indicate that the date of the alleged offense in this matter is August 9th of 2024. I was not counsel to the defendant when she was originally arraigned, so I don't have that exact date, but I suspect it was shortly after the August 9th, which means that she's been on a tether, because that was a requirement of the bond at the time that it was set, for almost getting close to 2 years now. To my knowledge, there has not been any violations of the bond. If there were, I was not notified of any. And she's had no other contact with the criminal justice system since her arraignment in this matter. Now, that's on the positive side. On the negative side, Ms. Madison has indicated not only is it a financial hardship, which I'm sure the court hears from many defendants, but there are also specifics with regard to her case, and in particular that she is involved right now with some medical proceedings involving her legs, including physical therapy, and the presence of the GPS tether on her leg, A, is exacerbating her condition, and B, making the treatment very, very difficult. So the only modification we're asking, Your Honor, is that the court remove the requirement of the GPS tether.
Mr. Sneed?
Yes, Your Honor. I believe the tether was put on in September of 2025. I'm not aware of any violations, so I would defer to the court's discretion. Thank you.
I'm sorry, that Mr. Sneed is correct. It was, I wrote down 24, but it was November of 25. He's correct.
In looking through this file, there have apparently been some issues with the GPS and compliance with the curfew. There are several GPS violation reports in the file from September and October of 2025 for curfew violations. And there are also, I guess there's two pending contempts in the case. One is for the GPS violations, and the other is for some missed drug testing. Do you have, Mr. Goldstein, any information from a doctor that indicates that the GPS is somehow hampering her treatment?
I don't have it at this time, Your Honor. I can certainly get it.
All right. Well, based on the two pending contempts, I'm going to deny the request at this point. If there is some substantiation that the GPS is exacerbating a health condition or interfering with treatment that she needs to receive in a way that's medically harming her, then I would be willing to look at that again. But based on the circumstances as I can see them in the file, I think that the GPS appears to be appropriate at this point.
All right, we'll come back when I get that medical information, Your Honor. Thank you.
All right, so you can go ahead and log out for today then. Okay, Mr. Amadeo, do you want to speak to Mr. Lake? He had asked if he could say something to me before you got logged back in.
Yeah, could I speak briefly? I'll be very short, Your Honor.
Okay, and I am very sorry for the confusion and whips on you back and forth here.
No problem, Judge. I just rather speak to him than speak in open court, obviously, but no problem at all, Your Honor. Thank you.
Give me just a second.
Your Honor, according to my calendar, I think the people may be done. I don't see any other need for appearance unless the court has something on its calendar.
Yes, you are correct. I don't think I have anything else for you.
Okay, great. Have a good morning then. Thanks, sir.
All right, and Mr. Lamley, your case is going to be heard by a different judge. You're going to be seen by Judge Morgan.
Okay, I just saw him. Am I going to see him again? I just saw him for something else.
I don't know what you saw him for, so I can't answer that question for you.
He had a pending trespassing down there.
Okay, so the file he had up here. So I don't know. It sounds like you probably will need to see Judge Morgan again on your probation violation in the file that was assigned to him for ET court.
Okay, do you know about what time that'll be?
I don't have any idea.
Okay.
I'm gonna take a hammer and wedge it and get that. Maybe it's repeated, Jeff.
Yeah, it is. That's what I think.
All right, Mr. Cherry, I'm not sure where Ms. Underwood went off to, but as soon as she gets back, we can call your case.
Thank you, sir.
Okay, and so this is file 26-22571-FH, 26-22572-FH, and 26-22573-FH, People versus Richard Lewis Lake. We are here today because Mr. Lake was arrested on an alleged bond violation, and we are proceeding today by video conference. Mr. Amadeo, would you like to place your appearance on the record?
Yes, sir. Thank you. William Amadeo, P76194, BF Richard Lake. Consent to Zoom, and Your Honor, thank you for getting us in. Richard, please state your name, and he does consent to Zoom from the Lenawee County Jail.
Richard Lewis Lake.
Thank you.
Okay, I don't have. Don't have a complaint for a bond violation, but I do have some information from Madison Township Police Department that makes it appear that he had a PBT test of 0.192.
Yes, that's what I have as well.
Okay.
And
So
I'll wait for any formal reading, Your Honor.
Mr. Lake, the positive alcohol test would be a violation of your bond conditions. That would be a contempt of court. The maximum possible penalty for a contempt of court is up to 93 days in jail or up to $7,500 in fines. Do you understand that?
Yes, sir.
All right, Mr. Amadeo, do you know how Mr. Lake would like to proceed today?
Your Honor, I'd like to stand mute and be heard on bond. I have asked your staff for a meeting, a Cobb's meeting, which I would include this. I'm fairly certain we're not going to run a hearing on this, Judge, but just for my own due diligence, I do want to review the report thoroughly with my client and go see him in the jail. So if we could push this out to his pretrial, just add it to the pretrial, which I believe is on, I'm just checking it, May 20th at 8:15 a.m. And if I could briefly be heard on bond, if all that's acceptable.
All right, I will enter a not guilty plea for Mr. Lake and I'm sorry, what date did you say that was?
May 20th, Your Honor, at 8:15, we have his pre-trials.
Okay, so a week from today, we'll set it for May 20th at 8:15. And what would you like to say about the bond issue?
Thank you, Judge. First of all, I apologize. I know we're here for a number of issues with Mr. Lake. He has been battling substance abuse. He's been doing very well. He has outpatient at Dwan Farms today at 5:30. I don't want him to get kicked out of the program, which is not your problem, Judge, but this is one relapse. He really has been fighting this, and he's been doing better. I just don't want to set back where he's set out of the program. Again, not your problem, Your Honor, but I really am trying to help him with his sobriety, and I'm really working hard to try to get him his freedom. I know this looks bad, but he is in treatment. He's been doing well other than this hiccup, and I really want to try to get him out so he can continue treatment. I know there's going to be some punishment here, whether it be probation or jail, and I know we're negotiating that, but I really don't want his treatment being affected. Again, I apologize to the court for this violation, but I am trying to help this man. I think him not being able to go to Dwan Farms tonight is going to be a major setback. So for those reasons, I asked for a PR bond with regular testing. Thank you.
All right, obviously the primary concern, given this new information, is the substance use issue. Does he have the ability to do a scram?
Can you do a scram tether, Rich?
I don't even know what that is. Can you explain it?
It basically would be testing you on a regular basis.
It's an ankle unit like a GPS tether, but it doesn't have GPS information. It constantly tests your skin to see if you have been consuming alcohol.
I absolutely can, but the only thing is I would just need, like, if I could postpone the payment of it until I can get, because I'm working out there. I'd have to pay for it like today if I get out today. Might be able to. I got $180 in my bank account. That's what I got. That was all going to front of the court.
Okay, well, hold up. I'm fairly certain when you have fines and costs when this is over, you could pay then. But
That's
I
fine.
don't want. But
I'll do that GPS every single day, man.
Okay, Rich, let me talk, please.
Sorry.
I'm fairly certain, working in Judge Olsaver's court for a while, his biggest concern is that you're drinking, and he wants to make sure on a regular basis you're not drinking. So, number one, are you willing to put the scam tether on?
Yes, sir.
And number two, if he gives you that leniency, will you be able to pay for it at some point?
Absolutely. I have a job up there, a good one, actually.
Okay, Rich, please limit your conversation. I'm trying to protect you. I
Yes,
don't
sir.
want you to say anything. So, Judge, if you would order a scam tether, I believe he would greatly appreciate it.
All right, what I will do is issue a PR bond with the requirement that a scram unit be placed
That's amazing.
by Friday, May 15th.
Thank you.
Can I say one thing?
Go ahead.
I have my outpatient today at 5:30, and they said if I miss it, I'm out of the program.
Yeah, you can be released from jail today. You have to have your scram unit on by Friday, the 15th.
I'll be there.
Thank you, Your
All
Honor.
right, so you'll arrange that through Darren Coast, who you're already communicating with, I think, in pretrial services. And if you don't know how to get a hold of them, I'm sure Mr. Amadeo does.
Yeah, no
Yes,
problem.
sir.
Thank you, Your Honor.
All right, so you're all set. Yeah.
Darren is off on vacation and is not back until May 21st.
All right, we'll send the information over to its JSG that handles that for us. Mr. Amadeo will get you that information so that you can communicate it to Mr. Lake.
Thank you, Judge.
Thank you, Your Honor.
With that.
I apologize to the courts again. This is ridiculous, I know.
Thank you for getting us in, Your Honor. Have a good day.
All right, Mr. Lake, can you let the officer with you know that you're done with court?
Thank you.
Okay. Oh, go. Public Defender's Office and see where Rhonda is. What date did we adjourn the poll, Chair?
June 10th.
Yes. I have to be very careful not to say something.
Okay, this is file 22-20683-FH People of State of Michigan versus Paul Edward Cherry. Sir, you are Paul Edward Cherry, correct?
Yes, sir.
Mr. Cherry, I don't know what happened to Ms. Underwood after you had a breakout session with her, but she is no longer logged in. What we did discuss, we had called the case earlier before you got logged in and adjourned the hearing to June 10th at 8:15. We're pretty much just kind of kicking this out to track your bankruptcy filing, your bankruptcy case. So I'm just going to leave it at that, and you can go ahead and log out and log back in on June 10th.
Yes, sir. I thank you. Thank you very much.
So you're all set. Thank you for your time.
All right.
Ken.
I've got to step out for a moment. I'll be right back and we'll get started on the whole house.
Yeah, no problem. Wow. It was not. It was interesting. Okay, I'm looking at the witness. I remember there's no witness. Yeah. Yeah. That's what I thought Zachary. Yeah. I'm not looking at the witness. Oh, yeah. We didn't have her tap in. Yeah. I was on there. Oh, yeah. I'm the figures. Just like he tried to convince me the game was going to be canceled tomorrow night. They're still going. Are you? Just watch at the same time. One on here and one
All right. So we're in the session. You may be seated. This is file 22-21196-FC, People versus Andrew Wolhousen. We are here today for a hearing on a motion for new trial, and we are proceeding today partially in person and partially by video conference. Going to have the attorneys place their appearance on the record, beginning with Ms. Pellet.
Good morning, Your Honor. Melissa Pellet on behalf of the people.
Good morning, Your Honor. Mark Linton on behalf of the defendant, Andrew Wolhousen.
All right, and sir, you are Andrew Wolhousen, correct?
That is correct, Your Honor.
All right, Mr. Linton, this is defendant's motion for new trial. You can proceed with any argument you have at this point.
Thank you, Your Honor. I'd like to start with the Brady violations and missing evidence. In particular, we have Detective Keene admitted that videos were never provided to the defense. One of the strongest points now established directly in the trial transcript is Detective Keene's admission that videos she previously claimed were preserved were never actually provided to the defense. During continued cross-examination on July 21st, 2025, Mr. Amadeo questioned Detective Keene regarding the October 19, 2021 Patterson family recordings. Now, Detective Keene admitted, or when she was asked, she admitted that you did not receive some videos. Yes, she's admitting to that fact. And that's in July 21st, 2025, trial transcript volume 5, page 8. Now, this is critical because the prosecution has repeatedly argued there was no suppression. Detective Keene previously testified the videos were preserved, and the defense is affirmatively led to believe the evidence existed. This directly supports the defense argument that the favorable evidence was withheld or lost in violation of Brady v. Maryland, as well as Giglio v. United States and People v. Chenault 495 Mich 145, a 2014 case. Now, Detective Keene contradicted herself under oath. The transcript now demonstrates multiple contradictory sworn statements. On July 25th, 2025, Detective Keene admitted, when questioned, did you later send an email on July 11th saying those videos are not in place because they did not merge with the body cam transfer? Answer, yes. Again, that was in trial transcript volume 5, pages 7 and 8. But earlier, she testified the videos had been preserved. The testimony where Detective Keene stated that the videos had been preserved again on July 21st, 2025, jury trial volume 5 transcript during Mr. Amadeo's cross-examination, which Mr. Amadeo asked, "And did you testify that you preserved those videos on July 10th?" To which Detective Keene answered, "I preserved those, yes." This can be found on volume 5, page 7. Immediately afterward, Detective Keene admitted that she later sent an email stating that the videos did not merge with the body cam transfer and that the defense did not receive some of the videos. Specifically stated when, "Did you later send an email on July 11th saying those videos are not in place because they did not merge with the body cam transfer?" Answer, yes. And when you say you preserved the videos, did defense counsel ever get those videos or not? Answer, you did not receive some videos, yes. That's volume 5, pages 7 through 8. This contradiction is extraordinarily important because the prosecution's response attempts to portray the missing evidence issue as merely technical or immaterial. The transcripts now show the evidence existed. Detective Keene admitted it was preserved. Detective Keene later admitted it did not exist. And Detective Keene admitted the defense never received it. This is far more serious than a routine evidentiary gap. The court itself recognized ongoing confusion about the missing videos. I feel strengthening the motion is that the court itself repeatedly acknowledged confusion surrounding the issue of evidence preservation. During the July 21st, 2025 proceedings, the court stated, "We're again reaching a stage where there's confusion about the use of the word preserved, which we've discussed before," and that's in volume 5, page 7. This statement is powerful because it demonstrates the confusion was not created by the defense. The court recognized the ongoing inconsistency in the testimony, and the evidentiary issue remained unresolved even during trial. Further, Deputy Chief Van Alstyne directly undermined Keene's explanation. When Van Alstyne testified, he made it very clear that 100% of the videos that were provided were transferred as part of the transfer process, which contradicted Detective Keene's explanation for the missing videos. During cross-examination, Mr. Amadeo specifically questioned Keene about Van Alstyne's testimony regarding the Axon migration. Question, did he say he's the one that did the merger? To which she answered, yes. And that's volume 5, page 8. This supports the defense argument that Keene's explanation about the videos being lost in the transfer process were contradicted by supervisory testimony. Next, I'd like to address the juror misconduct and the juror impartiality. At one point, the court halted trial proceedings over a juror issue. Now, the prosecution seems to minimize the juror misconduct concerns as speculative, but the transcripts demonstrate the issue was serious enough for the court to interrupt trial proceedings and conduct an immediate inquiry. On July 17, 2025, the court stated, "There is a potential issue with respect to the jury that I have discussed with the attorneys, and I think all agree at this point that we need to conduct a hearing to determine exactly what the issue is and how to respond to it." That is in trial transcript volume 3, page 5. That statement is significant because it demonstrates the issue was credible, the court believed formal inquiry was necessary, and the concern was sufficiently serious to stop the trial midstream. Now, the jurors were individually examined. The transcripts further show the court individually examined numerous jurors concerning the hallway communication issue. That can be found in volume 3, pages 40 through 65. Now, this substantially strengthens the defense argument that misconduct issue is not trivial or speculative. In particular, we have Todd Meyer's report that was serious enough to trigger the immediate court intervention. And the court response itself validates the seriousness of the issue. The court stated, "I think all agree at this point that we need to conduct a hearing," volume 3, page 5 of the trial transcripts. This undermines the prosecutor's later attempt to portray the allegations as unsupported speculation. Since that time, we have learned additional information in the form of newly discovered evidence of juror misconduct, which was not limited to the isolated hallway comment or speculative concerning regarding casual familiarity. The newly discovered evidence demonstrates a pervasive pattern of undisclosed overlapping relationships involving jurors, the complainant, the lead investigator, who all seem to center around the same church community at One Mosaic Church in Adrian. The cumulative nature of those undisclosed relationships destroyed the appearance of impartiality required by the Sixth Amendment. The United States Supreme Court has long recognized the criminal defendants are constitutionally entitled to a jury capable and willing to decide the case solely on the evidence before it. And that's Smith v. Phillips, 455 U.S. 209, 1982. Michigan courts similarly recognize that the proper inquiry in juror misconduct cases is whether a defendant was denied the right to an impartial jury. And that's People v. Miller, 482 Mich. 540 2008 case, and People v. Budzine, 456 Mich. 77, 1997. Here, the newly discovered evidence demonstrates that the jury selection process failed to reveal substantial overlapping relationships directly connected to the complainant, Detective Keene, and jurors. Most importantly, the court itself recognized during the trial that the issue was sufficiently serious to halt the proceedings. However, the evidence uncovered after trial demonstrates that the abbreviated Remmer hearing conducted during trial did not fully expose the breadth of the undisclosed relationships. The newly attached juror misconduct materials explain that defendant retained private investigator Joseph Odell following trial to investigate the truthfulness of the juror statements, denying familiarity with anyone involving the case. The investigation revealed that One Mosaic Church was attended both by the complainant and Detective Keene. Jurors were present together at civic and social events. Jurors were connected through the Raisin Valley Golf Club and Wagley Group. Multiple jurors may have known one another despite denying prior familiarity. The jury four-person's son's wedding was officiated by a pastor from One Mosaic Church. There's also evidence of Facebook posts that were erased that concerned One Mosaic Church and juror Rodney Clark. Now, this evidence is significant because Detective Keene was not merely an investigator assigned to the case. Defense motion established that Detective Keene served in a leadership media role at One Mosaic Church as its media director. The new evidence therefore establishes not simply the church attendance, but a concentrated and overlapping social network involving the complainant, the lead investigator, and jurors. The juror misconduct materials further explain that despite questioning during voir dire and again during the court's inquiry on July 16th, no juror disclosed any affiliation with One Mosaic Church, the Raisin Valley Club, or the Wagley Group. This omission is critically important because during voir dire, the court specifically instructed jurors to examine whether they recognized one or another or had prior familiarity when the court stated, "Those of you drawn into the jury box at this point, take a look around at the other jury members or other members that have been drawn into the jury box and just let me know if any of you have known each other prior to this morning." That's volume 1, page 77 of the trial transcript. Juror Rodney Clark then affirmed there was nothing to discuss, and that's on page 2 of volume 1. But the post-trial investigation uncovered evidence suggesting that the complainant, jurors, and Detective Keene attended the same church, participated in the overlapping social events, maintained relationships through common organizations and family events. And frankly, it's inconceivable that if any of these members that go to One Mosaic Church would not know of the leadership of the church, who is listed specifically on the website as Detective Keene. Now, the significance of this evidence is cumulative. Standing alone, one overlapping relationship might appear innocent, but the constitutional problem arises from sheer concentration of undisclosed overlapping relationships involving multiple juries, the complainant, and Detective Keene. As stated in our motion, there simply is no way to believe that not one single person in the courtroom during the trial of the complaining witness, the Detective Keene, or the jurors knew each other. The new evidence also substantially strengthens the defense argument that the court's abbreviated Remmer hearing did not resolve the broader impartiality problem. Juror misconduct materials additionally reveal more issues. In particular, we have an issue where a YouTube video was posted on August 27, 2003, which the complainant is being baptized, and then he gives a statement regarding the allegations concerning the defendant. Since Detective Keene is the listed media director, it certainly would seem plausible that she was the person recording the video as well as the person who posted it, and certainly would have known about the video. And if you do review the video, you can see a large crowd is present, again suggesting another high probability that some of the jurors were present for that event. Some additional evidence is being that Anthony Freer, the complainant's brother-in-law, lives very close to Foreman Rodney Clark. We also have some strange issue with Maria Clark, another juror, her former teacher, posting about the case on Facebook during the trial. Now, I don't know if the court recalls, but there seemed to be a lot of people at this trial, and it appears from the evidence that the congregation of One Mosaic Church was actively there watching this trial and actively communicating each other within a group chat, as witnessed by Mr. Todd Myers. Now, the additional evidence changes the constitutional analysis because in the court's inquiry focused primarily on the hallway communication, it did not encompass the broader network of undisclosed relationships I uncovered after the trial. Now, currently, there is an outstanding subpoena to One Mosaic Church who has not responded and indicated that they are waiting for their attorney to get in contact with me regarding any information they have regarding these individuals as to their affiliation with this church. Under the Remmer v. United States and People v. Budzine cases, I would cite that when external influences or undisclosed relationships create a real and substantial possibility of juror bias, the court must determine whether the defendant was denied fair and impartial trial. Now, the prosecution attempts to dismiss these concerns as speculative and argues there is no rule prohibiting the jurors from, again, attending the same church. But the defense argument is not merely that they attended the same church. It also includes the fact that the complainant attended the same church. Detective Keene is a leadership media position at the church, as well as the jurors who are connected with this church. The relationships were not disclosed during voir dire. There are two jurors who appear to be related to each other in the form of Courtney Ray Anderson Sudem and Garrett Robert Sudem. The overlapping social and organizational relationships existed, and these issues surfaced only after the trial, despite the jurors denying familiarity with one another with the individuals connected to the case. Now, the appearance of partiality created by these undisclosed overlapping relationships independently undermines confidence in the verdict and at minimum requires a full evidentiary hearing under Remmer and Budzine. I'd like to just touch on a couple of other topics. One being the issue of the prosecution's repeated emphasis on defendant being complainant's coach, despite acknowledging outside the jury's presence that the coaching status was not part of the relevant charged conduct. On July 16, 2025, defense counsel reminded the court that we had a pretrial motion hearing, and Ms. Palapoo stated being a coach is not an element of CSC 1. And that's in trial transcript volume 2, pages 5 through 6. Defense counsel further argued that yesterday in opening, Ms. Palapoo said he was the coach the whole time, and that's volume 2, page 6. This supports the defense position that the prosecutor improperly used the emotionally charged coach label to bolster credibility and inflame prejudice. There's also additional support for materiality under Brady because the prosecution argues that the YouTube video was immaterial because the complainant's testimony was already consistent. Now, this video was posted on August 27, 2023, almost 2 years prior to the testimony at the trial. Now, the prosecution's own closing argument demonstrates why impeachment evidence was critically important. During the closing argument, the prosecutor emphasized these witnesses were all consistent, and that's volume 6, page 7. The victim's testimony at trial placed portions of the alleged conduct at ages inconsistent with his public YouTube statement describing the relationship as occurring from the ages 13 to 17. That inconsistent materially strengthens both the Brady argument and the newly discovered evidence argument because it directly undermines the prosecution's repeated claim that the complainant's allegations were consistent. The key legal point is that Brady materiality is evaluated cumulatively and in the context of the prosecution's theory at trial. Support for that is in the Kiles v. Whitley, 514 U.S. 419, 1995, where the prosecution repeatedly argues witness consistency and credibility prior inconsistent statements affecting timing, age ranges, duration of abuse become especially material under the Giglio and People v. Chenault case, 495 Mich. 145, 2014. Now, here again, the prosecution emphasized during closing statements that the witnesses were all consistent. The argument becomes significantly weaker if the complainant publicly describes the relationship as occurring from ages 13 until 17, while trial testimony placed key charge conduct beginning substantially earlier. For example, during trial, the complainant testified regarding events allegedly occurring when he was 12 years old and in 7th grade. In July 15, 2025, trial transcript volume 1, the complainant testified regarding the timing of the alleged conduct and stated he met defendant while attending youth basketball activities and that activities began while he was approximately 12 years old. That's volume 1, pages 92 through 96. The complainant further testified regarding overnight stays, hotel trips, and alleged sexual conduct occurring before age 13, and that can be found on volume 1, pages 109 through 121. Now that timeline materially differs from the YouTube statement in which the complainant characterized relationship as occurring from 13 to 17. And that would also come the question of if his memory would have been closer or more intact earlier when that video was posted on August 27, 2023, compared to when he testified on July 15, 2025. Now, the significance of the inconsistency is not merely semantic. The age was critically important in this prosecution because several charges depended upon the complainant's age. The prosecution repeatedly emphasized the defendant's role as coach during early adolescence. The prosecution argued, a long-running grooming pattern before age 13. I think certainly that if the complainant publicly described the relationship as occurring from ages 13 to 17, that statement directly undermines the prosecution's trial narrative that sexual conduct and grooming began significantly earlier. Because age and timing were central to the prosecution's theory, the statement constituted materially favorable impeachment evidence under Brady and Giglio. This becomes even stronger when tied to the prosecution's repeated consistency arguments during close. The court should be reminded that materiality does not require certainty of acquittal. Under the Kyles v. Whitley case, the question is whether the suppressed evidence could reasonably undermine confidence in the verdict. Now, the prosecution cannot simultaneously argue the complaint was unwaveringly consistent and that timing and grooming chronology proved credibility. The relationship began during early youth coaching years, while dismissing a public statement by the complainant himself describing the relationship as occurring from ages 13 until 17. The inconsistency goes directly to credibility, chronology, grooming allegations, coaching-related influence, and the reliability of the prosecution's narrative. Additionally, because the prosecution relied heavily on corroborative consistency rather than physical evidence, any prior inconsistent statement regarding the timing becomes particularly significant under the Napu v. Illinois case. That's 360 U.S. 264, 1959, the Giglio case, and People v. Ackerman, 257 Mish App 434, 2003. I would just touch on one last thing regarding the ineffective assistance of counsel. As laid out, Mr. Wolhousen's trial attorney quit 6 days before trial, citing he had a conflict. As we provided, we showed a register of actions to show that he actually had to go appear for a traffic ticket for his boss, Scott Grable. Mr. Grable is the one that called Mr. Wolhousen to inform him that Mr. McCrory would no longer be on the case and that he was going to make Mr. Amadeo chief trial counsel and that Mr. Nassif would then take second chair. When Mr. Wolhousen asked, is there anything else we can do or do I have a choice? Mr. Grable said flatly, no. It would be noted that on July 25th, it was that Mr. Nassif stated, I did just file my appearance to the court. Mr. Nassif came on the case very, very, very late, days before the start of trial, and Mr. Nassif took on the critical role of cross-examining the complaining witness in this case. Clearly we have a very highly technical evidentiary issue in that that was an extremely compressed time frame for him to get up to speed. That would conclude my oral argument, and I would be happy to ask any questions.
Ms. Falcon.
Thank you. Defendant's motion argues several different things. One being, I'm just kind of going to go in order that it was in the motion as best as I can, Your Honor. The first thing that I'll talk about is the videos that defense counsel is bringing up, and those being the videos that we held an evidentiary hearing on already. And so This court has already ruled on that matter. This court has already heard testimony regarding this and has already been briefed on this and has reviewed the law and the testimony and has made a ruling regarding that evidence. If you think back to the hearing and to the testimony in court, both in the trial and at the hearing, it's the semantics that everybody kept fighting over with that word preserved. And if you remember, Detective Keene thought of that word differently than Mr. Amadeus did. And so when she was saying that she believed everything was preserved and that everything was there for the merger, but she didn't do the transfer, but she believed everything was there. And the testimony of the person who did the transfer said, well, he believed everything came over, but he never compared any evidence logs or any of those lists to make sure that everything came over. That's what the testimony was regarding the videos. There was no Brady violation. Those videos were not, I do not believe that there was a Brady violation or any prosecutorial misconduct regarding those videos, and this court, again, has already heard that issue. Regarding the second allegation of a Brady violation and prosecutorial misconduct for not having provided a YouTube video of the victim's baptism, where he did give a brief statement regarding his path to finding God. In that video, if you've watched that video, this is what he says. It's a very short statement. He's not questioned about the specifics of the assault. He's not even asked any questions. He doesn't go into the specifics of anything. He says very generally that soccer was his favorite sport, that he joined a new soccer program at the age of 11, where he became very close with the main coach, who also became close with his family, stayed at his house, and bought him expensive gifts beginning when he was 11 and 12. Slowly and methodically, it turned dark and inappropriate. That's a quote from Jacob in that baptism video, leading the victim to believe that he was in an actual relationship from the ages of 13 and 17. He does not describe the concept of that relationship. He just says he believes he was in an actual relationship. And if you remember his testimony, that is exactly what he said there. He testified to the grooming, he testified to some of the touching, but then he testified to believing that he was in a relationship with him when he was about 13, all the way through until his belief of the relationship ended. If you watch this video, note that he did not say that age 13 is when the grooming or assaults began. It's just when he believed he was in a relationship with a grown man. He also talks in that video about the defendant moving away, him realizing that it was wrong and having a mental health crisis and resenting God for what happened to him. In People v. Schumacher, which is 276 Mishap 167, a 2007 case, and People v. Cox, 268 Mishap 400, a 2005 case. In order for this video to be a Brady violation, the defendant would have to show that, one, the people possess the evidence favorable to the defendant fails this prong. Even if you want to say that Sergeant Keene, because she is on the technical services part of the church, should have known this video existed and should have provided it to the people. It was not evidence, it's not material evidence, and it did not need to be turned over. It was not a part of this case. But even if you believed that Sergeant Keene should have turned it over, it's far from exculpatory. This is one of the most prior consistent statement videos that I've seen. And it would have been very impactful if the people had the ability to put it into evidence to show a prior consistent statement. If we could have somehow got that in through the court rules, which I don't believe we would have been able to. There was no inconsistency. There was no ability to impeach him on this very short video. And it was a very impactful video that shows that he hated God because of the assaults that the defendant had perpetrated on him and this years-long abuse, and broke down and then found God again. That's what that video is talking about. Also, the defendant would have to show that he could not have found it with any reasonable diligence. He would fail this prong as well, as he did find it, obviously, right now from doing probably a Google search or just looking on the church's website. And if you remember, the defendant had was following people during the course of this, of the pretrial proceedings and the trial proceedings, and was constantly looking on the internet for the victim. Hence that entire incident where the defense attorney had found the victim on the internet, pretended to be interested in real estate, and set up a meeting with the victim. So he could have found this video as well. Third, the defendant has to show that the prosecution suppressed the evidence. Again, he would fail this prong as well. We did not even know it existed. The OIC did not intentionally not provide it either. She didn't even consider it as evidence. It was something that happened at the church that she didn't even think about. She said she might have uploaded it, but she didn't remember anything about it. And finally, the defendant has to show that if the evidence had been disclosed to the defendant, there was a reasonable probability the outcome of the proceeding would have been different. The defendant fails this prong as well. This is incredibly favorable evidence for the people. It's a prior consistent statement. It's very emotional. It would have been very damaging had they tried to put it into evidence. So he does not meet any of the prongs of a Brady violation. Also, that goes with the prosecutorial misconduct. I'm not entirely sure how the defendant believes this is prosecutorial misconduct. He does not provide any real specifics about prosecutorial misconduct in his motion, but it does not meet any threshold for prosecutorial misconduct as well. In going with the next group of arguments, which is the juror misconduct. So a new trial is warranted upon a showing. And I'll say for the Brady violation as well, there's been no evidence presented that Sergeant Keene knew anything about this video, that she in fact is the person who placed this video on the website. There's nothing from the church, there's no affidavits, there's no evidence that has been provided other than a screenshot that she works in technical services for the church. Nobody questioned her on it. No affidavits were provided by the church that she's the one who uploaded this video or shot this video or had anything to do with that. In regards to the juror misconduct, so a new trial is warranted upon a showing of juror misconduct if the defendant can show the misconduct affected the impartiality of the juror, which is People v. Dunnigan, 299 Mich. App 579, 2013 case, and People v. Nick, 360 Mich. 219, a 1960 case. And the challenges for cause for grounds of like what would make a juror impartial can be found in NCR 2.511E, which I did put into my brief as well. So the alleged statement, with the first part of juror misconduct that has been discussed is this alleged statement in the hallway that occurred during trial. And if you remember, Your Honor, this court heard this allegation. We got an email very early in the morning, or maybe it was late at night after the trial had ended the previous day, from Mr. Amadeo saying that there's this issue, that Todd Myers overheard people talking in the hallway. This court then looked at the videos that came from the hallway, found everybody who was in the hallway at that time, brought everybody in, put them under oath and questioned them, and then individually brought out the jurors, put them under oath and questioned them. This court already found that there was no merit to those allegations and did not find that Todd Myers was credible. So that situation had already been handled. And that statement, there's no evidence other than Todd Myers saying those things, which this court has already taken testimony on. The next batch of things that are being talked about are these observations from a private investigator that began following jurors after the trial concluded, after their oath was completed, after they had already done all of their work. And these observations, I'll also mind you, there's no affidavit for these observations. There's no evidence. There's no naming of these specific jurors, so we even know who they are. There's no attempt to contact the jurors and affidavits from the jurors. There's no photographs of these jurors conversing. We have no evidence they're talking about the trial. We have no evidence they know the victim. We have no evidence they know the detective. There's over 300 people in this church. There's no evidence they're all sitting together in the church or attend the church regularly. They may be on the books, but there's no evidence that they even attend, which would be truthful of Jacob as well. He does not regularly attend that church. He was baptized there. The observations being that there are 8 unnamed jurors that attend one Mosaic church. And again, that's a church that has many members. There's unnamed and unknown jurors going to a golf club where 2 of the victim's supervisors also go. Again, no affidavit or evidence that they went together, that they talked about the case, that they know each other, nothing. An allegation that unnamed and unknown jurors attend the same community events, which again, there's no evidence that they were talking about this case. I don't see how community members attending a community event would be juror misconduct. And then there's also this allegation that 2 jurors live together and have the same name. In the defendant's motion, again, there's no evidence that's been provided that these individuals live together or are married or even have the same name. So I went through and I looked at the jurors that we seated, and we seated a Garrett Sudum and a Courtney Ray Anderson. In defense's motion, the names that he provides are Courtney Ray Hazard Sudum and Garrett Sudum. There is no evidence that defense now changed the name on the record to Courtney Ray Anderson Sudum. That was not in the motion. And there is no evidence at all that there is a Courtney Ray Anderson Sudum. There's no evidence at all that there's a Courtney Ray Hazard Sudum. There's no evidence at all that Garrett Sudum is married to anybody or living with anybody. There's just no evidence of this allegation. These individuals during voir dire were questioned and denied that anybody knew each other, and there's no evidence that that was an untruthful statement. The other allegation is that juror Rodney Clark had his son's wedding officiated by somebody from Mosaic Church. Again, there's no evidence that there was any type of misconduct that occurred regarding this. There's no evidence that Detective Keene was there officiating it or even at the wedding. There's no evidence that Jacob Patterson or any of his family was at this wedding, just that Rodney Clark had somebody from the church officiate his son's wedding. And then there's this other allegation, this final allegation of juror misconduct, that's that Rodney Clark lives within 700 feet of a family member of the victim, which would be Mr. Frears. Mr. Frears doesn't actually even live at that location. There's no evidence that he lives at that location. I happen to know he does not live at that location. That's just a lot that he owns. There's no affidavit that Rodney Clark and Mr. Frears know each other. In fact, you questioned the jurors on whether they knew Mr. Frears, and they all said no. So there's just no evidence regarding these observations from the private investigator, nor was there an affidavit from the private investigator detailing these allegations. So defendant has provided no evidence of misconduct, no photographs, no videos, no affidavits, no records, absolutely nothing to show any type of misconduct, nothing to show the jurors colluded or inappropriately discussed the case prior to deliberations, nothing to show the jurors knew any of the witnesses, apart from what was already placed on the record, nothing to show that the jurors' conduct was inappropriate, nothing to show that they even knew each other in a way absent being general community members. So there's no evidence of any juror misconduct. And then, finally going to the claims of ineffective assistance of counsel. To establish ineffective assistance of counsel, the defendant bears the burden of showing that trial counsel's performance fell below an objective standard of reasonableness, and the deficient performance prejudiced the defendant, which is but for the counsel's deficient performance, a different result would have been reasonably probable. People v. Armstrong, 490 Mish 281, a 2011 case. And you cannot substitute your own opinions or use the benefit of hindsight, which is People v. Petrie, 279 Mish at 407, a 2008 case. So there's this claim that the primary defense attorney, Mr. McCreary, quit 6 days before trial. We had this case for a very long time, Your Honor. Mr. McCreary never filed an appearance. He never showed up in court ever. He never wrote any motions or argued any motions, of which there were substantial. He was never a part of this case. And there's no affidavit from Mr. McCreary indicating that he was a part of this case and that he had prepared for trial. He was a name that maybe was thrown around every once in a while, but never had no involvement in this case whatsoever that there's any evidence of, or that I have any knowledge of. And this case went on for a very long time. There's no affidavit provided that he was the trial counsel. There's no evidence that he was even prepared to try this case. And the two attorneys that were here were prepared to try the case. They came in with their own exhibits, with their own witnesses. The defendant was voir-dired regarding the new attorney coming in because he hadn't filed an appearance before. All of that stuff was placed on the record, and he picked those attorneys. Those were his attorneys that he chose. Mr. McCreary was never one of those attorneys that ever was coming here and ever did come here. Regarding the no expert on the forensic interview, this is not a type of case that even would have an expert on a forensic interview. The victim was 17 or even 18 when he disclosed. The people did not discuss the forensic interview. The forensic interview is not how the victim first disclosed. And to be honest, it was quite irrelevant in this case. There was no cross-examination with the victim on the forensic interview. So that there's no ineffective assistance of counsel for bringing in an expert that was not needed in this case. Additionally, saying that the defendant didn't get told that he had the right to take a polygraph, I actually believe that is false. I believe we placed on the record many years ago when the case first came out. I believe we put it on in the district court, and I believe we put it on when this case first came out. I know Mr. Amadeo and I did discuss it. There's no affidavit saying that that did not happen. Again, I believe that it was discussed in the court hearings. I know that it was discussed between myself and the attorney. And additionally, the defendant would have to show that any error in him not being advised of his right to a polygraph had to be outcome determinative, and the court must examine the nature of the error and assess its effect in light of the weight and strength of the untainted evidence. People v. Phillips, 469-ish, 390, a 2003 case. The court in Phillips went on to say that given the strength of the prosecution's case, it is not more probably than not that the error was outcome determinative. And even if the defendant had taken and passed a polygraph test, the results would not have been admissible at trial. That again is People v. Phillips, and they were citing People v. Ray, 431-ish, 260, a 1980 case. It's a harmless error test. So finally, the defendant also makes a general allegation that the trial counsel skills fell below that of an ordinary criminal defense attorney. However, he fails to provide any evidence or any specific examples of how that level fell below an ordinary defense attorney. So I believe that there is no evidence whatsoever that has been placed in this motion or provided to the people regarding any Brady violation, any prosecutorial misconduct, any juror misconduct, or any ineffective assistance of counsel. Yeah.
All right, Mr. Linton, do you care for rebuttal?
Yes, Your Honor. I would note regarding the issue of the videos with Detective Keene, the problem is this. She initially admitted that the video was preserved. She then claimed the video was lost as part of the merger. Now, that was completely rebutted when the lieutenant came in and testified that 100%, they went to the computer system and checked, 100% of the materials provided, and 100% of the materials were then merged. That means, and you can only reach the conclusion then, that she deleted the video. There is no other conclusion that can be reached. Is regarding the jury members, if the jury members would have lied not once, but 2 times, initially during voir dire, and then being brought back a second time to ask if you know anyone, the parties, witnesses, other jurors, anyone associated with this case, to which they also denied it. So they would have not lied but once, but 2 different times, which clearly the jury misconduct. They went to the same church as the complainant and the detective, and they were out to get Mr. Wolhousen. I'm not sure how the prosecutor would know where Anthony Freer lives. That seems kind of odd to me. I can represent as far as Mr. McCurry, that Mr. Wolhousen met with Mr. Curry multiple times about the trial, and he met with him as late as 7 days before the trial. And at that point, he was told that they're preparing. There was multiple binders laid out prepared for trial. And then for some unknown reason, the very next day, Scott Grable, the head of the firm, called Mr. Wolhousen to tell him McCurry's off. So he lost his trial counsel 7 days before trial. And there's a reason that Mr. Amadeo was supposed to be second chair, because he's not fit to be lead trial counsel. Regarding the polygraph exam, in a CSC case of this nature, there's a statutory right to have a polygraph exam administered by the police. It's a statutory right. It's there for a reason. And Mr. Amadeo never advised Mr. Wolhousen as to that right. I think clearly, given the issues that we've raised, at a minimum, the court should set an evidentiary hearing so that we can fully develop the record, as well as have an opportunity to have One Mosaic Church respond to the subpoena, which is something I anticipate could reveal some interesting additional information.
All right, I will start with the allegation of Brady violations. relative to the deleted video issue. The court has ruled on that issue previously, and in that ruling, it's been talked about here as a Brady violation. In the prior ruling, it was not found to be a Brady violation because with respect to those videos, there is no evidence before the court. There is not now, there never has been, that those videos were exculpatory or impeaching. And therefore, Brady is the wrong analysis for those videos. The proper analysis, as I have previously ruled and will rule again, is the Arizona versus Youngblood analysis, which holds that unless a criminal defendant can show bad faith on the part of the police, that the failure to preserve potentially useful evidence does not constitute a denial of due process of law. And that is what we have here. That is what the court has found. It was not, there's no evidence it was exculpatory or impeaching, which means that it was potentially useful evidence, because by definition, we don't know what those videos are. The court has already ruled that the failure to preserve those recordings was the result of an error transferring the videos from one software system to another, which I made extensive findings about after the hearing that we had, and I would rely on those findings to rule the same way today. I don't believe there's any evidence that's been presented to the court that would call that ruling or the reasons for that ruling into question. With respect to the alleged violation, Brady violation, as it relates to the YouTube video, I would find, having had an opportunity to review that video because the link was provided in defendant's brief, that that video was not, in my opinion, either exculpatory or impeaching. Defendant's position is that the victim in this case stated that a relationship or the events occurred when he was 13 to 17. But the actual words of the victim in this situation are quite important, and I think need to be a part of the record, which I'm not sure they are yet, because his actual words were not quoted. What he said was it happened when he was around 13, not from 13 to 17, as defendant asserts in his brief. And that statement is frankly consistent with his testimony at trial. So I don't believe that it was exculpatory or impeaching, and therefore it cannot be a Brady violation. With respect to the juror bias issue, I agree with Ms. Palapu that there simply is not evidence of these allegations that defendant is making. There isn't an affidavit, anything that tends to support the allegations that have been made. There's an allegation that 8 of the jurors were members of the same church. I don't even at this point know who those jurors are. apparently been a private investigator that was hired to investigate this. There's no statement or affidavit from him to support the allegations that have been made. And in the absence of that, I'm not going to presume that there must have been some kind of juror bias because of unsubstantiated allegations that don't have factual support in the record at this point. And so I would deny the motion on those grounds as well. And I further, at this point, don't believe that a further hearing is necessary on those grounds. The court did conduct a full and thorough hearing with respect to the one allegation for which there was some support in the form of the testimony of one witness. I made factual findings with respect to that issue, which included credibility findings related to the witnesses that the court listened to and observed during that hearing, and I would rely on those findings and conclusions with respect to that issue. With respect to the claim that two jurors live in the same household, again, there has not been any factual support for that brought forward. There's an allegation made by defendant. There does appear to be, based on court records of which I can take judicial notice, two people with the name Courtney Ray with different last names who have different birth dates. And based on what we have been able to understand from, again, the court records that are available to us, of which I can take judicial notice, they are not the same person. But even if I did not have that information available, defendant has not made any factual showing of any kind through an affidavit or other evidence that that two jurors were living in the same household at this time. With respect to the issue of the ineffective assistance of counsel, first, with respect to the generalized allegation that Mr. Wolhousen's attorney trial attorney left shortly before trial. Again, there aren't any affidavits or facts which I can analyze other than the allegations made by defendant in the brief. But I will say that Ms. Palapoo is correct. Mr. Wolhousen was asked about the switch in counsel at trial to ensure that he had met with his trial counsel, that he was comfortable in believing that co-counsel had been brought up to speed, and that he was not requesting any kind of adjournment or expressed any concern about late addition of new counsel. And so I don't think that there's any evidence of ineffective assistance of counsel on that basis. With respect to the issue of the failure to consult a forensic interview expert, It is possible, according to People versus Ackley 497, Mich. 381, that trial counsel may be constitutionally ineffective for failure to consult an expert witness. However, even if the court assumes that the first prong of the Strickland test is met, there is not any evidence here that consultation with an expert would have had any bearing whatsoever on the trial of this matter. There was no expert testimony in this case at trial. And I don't see any way in which Mr. Wolhousen would have or could have been prejudiced by the decision not to consult with a forensic interview expert. And so I don't believe that a new trial is warranted on that basis either. So for those reasons, I would deny the motion for a new trial.
Will the court issue its own order, or does one need to be submitted?
The court will issue its own order on that.
Okay, very good. Thank you.
All right. Thank you all for your time, and those hereby